is 55901 Charles D. Septowski. Mr. Septowski, are you ready to proceed?
Yes, sir.
You may.
Thank you, sir. Good morning. Thank you, members of the board, for hearing my case. My name is Charles Septowski, and what I'm going to do is...
Before we get started, I do need to make one announcement. David Gonzalez has recused himself from this matter because he was on the evidentiary panel that heard the underlying grievance. So we're proceeding with the full board except Mr. Gonzalez. Go ahead, I'm sorry.
No, that's great. And I would ask your assistance with letting me know when it's 15 minutes so I could reserve some time at the end.
I will do so.
Okay, thank you. Purpose today is to, my purpose is to attempt to have the disbarment abated or a substitute penalty or a reversion of everything. Now, that's a big, tall order, so I would hope to have the greatest orator possible here to do this. Unfortunately, you got me. So we're going to work as best we can. What I'm going to start with is a short little story. Got a fellow over in Travis County Jail. He's 72 years old, has had a hip replacement, ankle rebuild, 3 cancer surgeries, removal of a kidney. He has nausea from the cancer radiation treatment. And instead of getting a prescription, he got marijuana. Marijuana is medically approved in 34 states, Texas not being one of them. So he's spending 10 days over in jail. Had he had a prescription for a drug called Miram, M-I-R-A-M, it is a synthetic marijuana for nausea. So the form of the transaction that he engaged in, which is substituting the real thing for the synthetic, resulted in his incarceration and breaking of the law. Form over substance. Because the substance is exactly the same. We as lawyers work regularly talking about form over substance. We regularly talk about trying to get to the substance of the matter and seeing what that merits. And that's what this appeal today is about, the substance of the matter. We're also going to talk a little bit about a lack of a full record, and then finally one provision of the judgment of disbarment that is overreaching. Specifically, the allegations that I've created misconduct, and I believe one of the prior disciplinary counsel described it as severe egregiances that warranted penalties. Y'all have looked at my papers and you've looked at the pleadings in this matter, and I, no question about it, committed errors. I had a payment of dues that was late, but I had a receipt and confirmation. Computer follow-up because I had a typo in the...
I think rather than...
Let me continue if I may.
Right.
No.
And this will be relevant, and I promise it'll be short.
I'll wait. To ask his question.
I'll wait.
Okay. And that was transformed into practicing while administratively suspended because I never got the notice. Subsequently, I did my CLE. It was timely done. It posted 8 minutes late. I tried to get an extension. I went and paid the penalty. I paid it to the wrong box. That resulted in a subsequent administrative suspension. And again, I paid it as soon as I knew about it. Those are both described later in the disbarment proceedings as intentional acts ignoring the pronouncements of administrative suspension. For something to be intentional, you gotta know it. I didn't know it. My third allegation is that I withheld a worthless escrow, and yet I had to sue the person to take it back, and there was an acknowledgement that that wasn't, in fact, a legitimate complaint. And the fourth allegation is the best one. That's the best one of all. Because while I'm on the suspension from this worthless escrow, opposing counsel intentionally pushes the case so that my client has to be represented. I attempt to get substitute counsel, it's all followed up, that's wrong. But in the course of the bankruptcy proceedings, there's final order that cut off activity, except the bar reaches beyond that and says, ignores the final orders, and says that's a violation too. Now, if we're talking about a system of egregious errors that warrant discipline, then I think that meets the standard. But it goes further. When we talk about this matter, we talk about providing a full and complete record. In the course of the disbarment hearing, all of the witnesses of mitigation, all of the statements and information and exhibits to mitigate were excluded. That doesn't constitute a full record. There was a request for a rehearing and the readmission of those same materials, which was denied. There was a request to expand the record for this proceeding and denied.
Did you, at the end, you had 10 witnesses for mitigation, the ones that you say were excluded. I'm remembering that each member of the panel confirmed that they would accept your tender of what those people would say. Am I understanding the record correctly that
No, sir.
they accepted the tender of what your witnesses would say?
No. One member of the board said, well, they'll all say something nice. It's okay, we'll acknowledge that. Mm-hmm. That's not sufficient.
Did you give any bill to present the evidence you thought that would be presented?
I'm sorry, I don't understand your question.
Did you preserve any record of what evidence you thought each of those 10 people would give that would not be cumulative?
Yes, they subsequently provided statements that I tried to admit during the rehearing, which were again excluded.
Mr. Septowski, did you use the name Cameron Chandler to file materials in bankruptcy court on behalf of Robert Farmer Jones and Esther Jane Jones?
No. Cameron Chandler was supposed to be the standing counsel. My assistant did not contact her, and we used her in error. And I apologize for that, but that was not to my knowledge, and as the deposition record reflects for Mr. Allums and the court proceeding in the bankruptcy court, I didn't know.
Did you have permission?
I'm responsible for that.
Did you have permission from Cameron to file?
No, my assistant never contacted her. I didn't know any of that.
At the time of the filing, you were under administrative suspension, were you not?
I was, and that's why we had substitute counsel, and that's why I had my assistant contact her, and that's why it didn't happen, and I didn't know. But it doesn't matter. And the reason it doesn't matter is because final orders of the bankruptcy court closed that issue. If there were any issues with regard to the filings, they had to be raised before that final bankruptcy order.
Are you saying that the state bar then or a complainant can't do anything about if it's perceived that filing was as alleged?
That's what res judicata is, sir. And the whole point is that was raised on appeal in the bankruptcy court. Because of this disbarment, it was summarily dismissed. Now, we all know that final orders preclude further review of anything. We know that starting back to the first grievance.
But the final order issued by the bankruptcy court directed the U.S. trustee, in addition to removing you from practicing in bankruptcy court in that district, instructed the trustee to provide the documents to the State Bar of Texas to consider whatever action was needed to pursue this on a disciplinary thing. So the final opinion specifically carves out and directs this to be looked at from a disciplinary point of view.
Yes, sir, it does. And that judge is wrong. She was wrong because she knows as well as all of us do that a final order precludes further review of the underlying issues. Now, that doesn't mean that, that's her opinion. We respect her opinion. She's a federal judge, okay? Doesn't mean she's right. Just because a cop has a badge doesn't mean he tells the truth. Just because a judge makes a ruling, it doesn't have to be right. But
whether it's right or not, at some point, doesn't it have some value?
It does. It does. And it should be reviewed. But in this case, the referral to the state bar is but one step that the state bar was pursuing. After the suspension over the worthless securities, there was a request for a competency or a psychological review of myself. I passed it without issue. So therefore, state bar investigators followed me, followed to see that I wasn't practicing law, looked into cases that had any case numbers that I had. Mr. Berry showed up in Dallas for this bankruptcy motion and quite possibly prepared it. We know that subsequently to that, there was a preparation of the grievance while this issue of the bankruptcy was being resolved. The point is, in the bankruptcy, we say the client paid all the secured creditors, did everything right. I've had 35 years of taking care of people. Since this disbarment, I'm precluded from practicing law, so I've been taking care of disabled people, taking them to doctor's appointments, helping them with filling out government forms. Not representing them, because I'm not allowed to do that, but helping them understand what the form is that says they can have their Medicare benefits or their VA benefits.
Let me ask you, what about the other allegation where it says, quote, allowing for non-lawyers in his office effectively to continue his legal practice while his law license was suspended? Can you comment on that?
Yes, sir, I can. My law clerk said, we'll get somebody and get back to you. That's it. That's what he did. We didn't have anybody get back to him. The suspension was but weeks from being over with, and so we let it sit. That's the letting somebody else handle my law practice. I have associates in my other practices in St. Louis and Detroit, and I called on some of them to handle things, but they were not Texas attorneys, so they couldn't respond to that.
Do you practice where else?
In St. Louis, Missouri, and in Detroit, Michigan.
And what's the status of your license in those places?
At this point, my status in Michigan is fine. I'm in good standing. In Missouri, I'm inactive because of some medical issues that came up. I had a heart attack.
Missouri?
Actually, I'm in the airport in Nashville.
So no, you're inactive in Missouri, you said?
Yes. Okay. The final thing that I want to bring to your all's attention is this issue of what's fundamentally fair. We've had procedural due process throughout this matter. Substantive due process is where there's actually somebody hearing it with an open mind, like y'all. Your all's job today, as I read the statute and understand it, is effectively a de novo review. You're looking at what's not only has happened, but also what a right outcome is from looking into all the facts, reviewing all the records. That, I believe, has been abused. In some regard, I became a targeted person over bar dues, over the CLE, over this worthless escrow, and then finally being followed around for the breach of suspension. That's
Mr.
not
Septowski,
enforcement.
You have 2 minutes, and
Thank
at least
you.
during that 2 minutes, can you tell us what penalties you would ask us to impose if we were going to consider something less than disbarment?
Well,
You think is appropriate?
yeah. In a perfect world, I'd ask you to wave the flag, send me away, and say, have a nice day. Realistically, I'd ask you to impose a suspension of a year or two. And because in all of the cases that are on the BODA website that I reviewed, there was criminal activity that constituted a basis for disbarment. There's no criminal activity here. And reasonably, I would ask that that be a alternative imposition of a penalty. I believe there's a fundamental issue, though, that needs to be looked at, which is the bar council said we want serious allegations to allocate our resources to. Bar dues and CLE and worthless escrows, those are not serious allegations. I shut down a multi-million-dollar money laundering scheme in that worthless escrow. My client retaliated with this escrow grievance, okay? That's not right. I shouldn't be the one standing here, but I am. Okay, so let's talk about reality. The reality is I've been found guilty of all these things, and the argument presented was that I regularly and routinely ignored the suspensions. The first two I didn't know about, and the third one I tried to not do anything except get a substitute counsel and stay out of the way, and I screwed that up. Okay, am I responsible for that? Of course, because it falls back on me, and a penalty should ensue for that, okay? None of that, absolutely none of that is serious penalties that harm the clients, their profession, or our legal standing. My disbarment, and this is part of what's so difficult, is I can't look to any mitigating information or any mitigating exhibits to tell you about a 40-year career of accomplishments, okay? But I can tell you about my credentials. I'm a lawyer, postdoctorate in tax law. I was CPA president here in Austin. I have a PhD in accounting. I've been accounting chair and business dean, advisor of the White House, okay?
Mr. Septowski, your time is up.
Thank you.
We'll give you a short time for rebuttal after you've written the panel.
May I proceed?
You may.
May it please the board, good morning. Still good morning, yes.
I'm sorry I referred to you as Ms. Hamlin. I meant Ms. Stevens.
No,
Thank you.
that's quite all right. The Board of Disciplinary Appeals should affirm Mr. Septowski's judgment of disbarment based upon the egregious misconduct that was demonstrated to the evidentiary panel below. And there are three topics I'd like to address with you all today. The first is that Mr. Septowski failed to adequately brief the issues before this board, and I'll be very short on that issue. The second is that even if you delve into the conclusory statements that Mr. Septowski does make in his brief, you will find that the issues are not a basis for reversal of this judgment. And lastly, and very, very importantly, the judgment is more than amply supported by the record that is in front of this board. And I'm actually going to switch up the order I was going to take this in. I'm going to go straight to the ample evidence that this board has to look at the record below that supports this judgment of disbarment.
Does a substantial evidence standard require here?
That's
apply
correct. Yes, Mr. Black. The substantial evidence, it's laid out in the disciplinary procedural rules that substantial evidence is the standard of review here. And I'm going to hit some highlights of the record below. You've discussed with Mr. Septowski the bankruptcy opinion. There's also a state court judgment finding that Mr. Septowski practiced while suspended. And I'd remind the board that this was a practicing while disciplinarily suspended pursuant to an agreed judgment. There were 3 months of active suspension, May through the end of July of 2013, to which Mr. Septowski agreed he would be suspended, and yet he still violated that judgment. So the state court judgment has a finding that he practiced while suspended from the practice of law. Mr. Septowski's own admissions in the record below at the evidentiary hearing regarding his claimed out-of-state exemption for the occupation tax, that supports one of the rule violations. He made an admission about his firm name, that supports a rule violation. Then we move into the bankruptcy court's opinion, and I'll point out a few highlights from that. The court found that Mr. Septowski's story is, quote, incredible and an after-the-fact fabrication. The court went on to find that Mr. Septowski had attempted to mislead the court with respect to his knowledge of material relevant facts. It found that Mr. Septowski prepared documents and pleadings that falsely represented Ms. Chandler's representation of the debtors and affiliation with his law firm during the suspension period. And I know you all know this, but I would point out again that Ms. Chandler was living in Alaska at the time, had not practiced law in Texas since, I think, 2009, had only been semi-affiliated with Mr. Septowski for one case where she represented him in Texas and then withdrew in 2009. She only practiced family law in Alaska. There was no contact from Mr. Septowski or anyone in his firm to get permission to use her name. There's essentially a stealing of her professional identity.
And she was not licensed, she was inactive in Texas?
That's correct.
And was not licensed in federal court?
Correct. And to further the fraud here, it's not only her name, it's a false state bar number that was used, and it was not her address in Alaska that was used, it was Mr. Septowski's law firm address. So she had no way to know that her name was being used to file bankruptcy documents for clients that she'd never heard of. The bankruptcy court's opinion went on to find that Mr. Septowski either filed directly or authorized Ms. Ports, this woman out of state, to file false documents and pleadings in the debtor's bankruptcy case during his suspension. Not only were these things presented to the evidentiary panel below, Bar Counsel brought in witnesses to testify about these issues, and then in addition to that, provided certified copies of the documents that were filed in the bankruptcy case. There is more than ample evidence provided to the evidentiary panel to support their judgment of disbarment. Now I'll move on to the procedural arguments that I had intended to start with.
Can I ask you one question?
Yes.
And I don't know if I'm getting way ahead or whatever. What is your view on whether any of the violations by themselves would result in disbarment, or is it necessary that we consider all of them?
Well, I think there's ample evidence to support each rule violation.
No, I'm not asking that. What I'm asking is, assuming each of the violations occurred, would each standing alone warrant disbarment, or do we have to consider the whole?
I think the answer is potentially. As this board knows, Mr. Septowski had 3 prior judgments of suspension against him, 2 of which I believe were fully probated and 1 was active. That is a consideration that the panel takes into account when determining what sanction is appropriate in the current case. And so that, coupled with any of those rule violations, might have resulted in disbarment. If I might flip to the rules. I think that, this is speaking off the cuff, but that each of those rule violations by themselves, coupled with the prior suspensions, would have been supported for a judgment of disbarment by this panel. But again, this board does not have to go there. There's ample evidence for each rule violation and support for the judgment of disbarment. I'll briefly address the inadequacy of Mr. Septowski's briefing, and then...
Counsel, why would the commission want to win the case on that technicality?
Well, that's why I was going to briefly address it, Mr. Black, is just to reiterate that this board and the courts are well aware that briefing must be adequate in order for the board to make a proper determination. This board is in a neutral position, and having to sort of pull out from conclusory statements arguments that counsel is supposed to make, go conduct research that might be supportive of those issues, and then scour the record for some supporting information, takes this board outside of that neutral role and makes you an advocate, and that's simply improper. And so that's why I wanted to address that, but I'm happy to move on to the substantive arguments if you would like.
We would.
I have a question first, sorry.
Yes.
Can you tell us what weight we should put on the fact that Mr. Septowski had witnesses that were going, he said representatives were going to mitigate the circumstances, and I think he said in his oral argument that he had other documentation that was not allowed. Can you expand on that?
I'm happy to. This is the last point, and Mr. Septowski talked about perceived procedural irregularities of the hearing. And for a board or a court to reverse based on the exclusion of the improper exclusion of evidence, you have to have 3 things. 1, you've got to have a preservation of the evidence that was excluded. And we actually don't get to the second 2 points because the first was not met. But the second is that the appellate court looks at that evidence and determines if it's material to an issue at hand. And then if it is, did the exclusion of that evidence probably result in an improper judgment? Like I said, we don't even get to the second 2 points because Mr. Septowski did not properly preserve the error at the evidentiary hearing below. And in fact, when he was told that the panel would not hear from these witnesses, he acquiesced. He didn't even say, I object to this, much less make a showing of what the evidence, or excuse me, the testimony would have been. And that is required by the case law. There must be at least a description of what the evidence would have been.
And why was it excluded?
I'm sorry?
Why was it excluded?
The panel decided not to, they just made a ruling that they would.
Well, actually, he had closed on the evidence.
That's true.
They had then closed the hearing, and then he said, now how about doing mitigation after they announced their decision, is my recollection.
Thank you, Mr. McKenna. That's
But,
correct.
but it is accurate, isn't it, that Jeff Bishop and Melissa Ward Meyer and Wayne Sharrow and others furnished letters afterwards? Did the contents of any of those letters in any fashion relate to mitigation issues that may have changed the outcome?
Well, I think the general characterization of those letters is that Mr. Septowski is a good guy. They don't directly go to any of the factors that the panel considers that are laid out in the procedural rules, such as a consideration of the harm to the client in the case, the harm to the profession, the, if I might step over and grab my book, I go through the factors, but to my way of thinking, they don't directly go to any of those factors. Okay. So Mr. Septowski makes 4 sort of general allegations, and I'm going to address those in turn. The first is an alleged conflict of interest by bar counsel, and he points to 3 different authorities to try to support this argument. The first is the Texas Rules of Civil Procedure. The second is Rule 1.06B1 of the disciplinary rules, and then also he mentions the 14th Amendment to the United States Constitution. The civil procedure rules, as we pointed out in the brief, there's really no tie to a specific rule, so it's unclear why Mr. Septowski points to the civil procedure rules when generally when courts are looking at whether to disqualify counsel in litigation, they look at the disciplinary rules for guidance. And so moving into 1.06B1 of the disciplinary rules, that rule essentially prohibits a lawyer from representing client A if that representation will conflict with the representation of client B, with the lawyer's own interest or the lawyer's law firm's interest. And there's really just not a scenario in the underlying litigation that fits 1.06B1. So that is not a basis for a reversal of this judgment. And then lastly, under this umbrella, Mr. Septowski makes a substantive due process sort of argument. And substantive due process protects citizens from arbitrary and capricious action. And as the board can see from the record below, this evidentiary panel did not act in an arbitrary way. There was substantial support for the decisions made in this case, and so his substantive due process rights have not been violated. Next, Mr. Septowski makes some general constitutional claims. He claims that his 4th, 5th, 9th, and 14th Amendment rights have been violated. The 4th Amendment protects against unreasonable searches and seizures. There was not a search or seizure in this case, and so it's really not applicable. Mr. Septowski mentioned some emails that had been subpoenaed by bar counsel. Those emails were not ever used in front of this evidentiary panel, and so he can show no harm based on that. The 5th Amendment protects against our right to not self-incriminate and protects against double jeopardy. There are a couple of problems here with the self-incrimination portion of that. Mr. Septowski never raised this at the panel below, excuse me. And as the case law points out, not only do you have to raise it, you have to raise it on a question-by-question basis. And it has to be raised in response to a question that the answer to the question would likely result in a criminal responsibility. And we can look at the record and see that there was no such question asked, and then even if there had been, Mr. Septowski is required to plead the 5th then and there on a question-by-question basis, and that simply didn't happen here. And then moving into the double jeopardy statement, double jeopardy prevents the second prosecution of a criminal case, and so that's just not relevant in this case. It's well settled that disciplinary cases are civil in nature. It's stated in the disciplinary rules as well as many cases affirming that. His 9th Amendment argument, the 9th Amendment says that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Mr. Septowski pointed to no specific right that he claims was abrogated here, and so we don't really get a full analysis of the 9th Amendment due to it's unclear what the argument is. Lastly, under the constitutional analysis is, again, the 14th Amendment argument. I addressed the substantive due process. I think Mr. Septowski in his argument actually conceded that there was procedural due process, but if I misunderstood that, I'll go ahead and describe it a little more, he has the right to have notice of the hearing and to participate in the hearing in a meaningful way. And in fact, he did have both of those. He was given notice of the hearing well in advance, and he actually attended the hearing, participated, and called witnesses and provided documentary evidence. And so his 14th Amendment rights to substantive and procedural due process were not violated. Lastly, Mr. Septowski has argued that he'd been unfairly targeted by the bar. And I think if this board reads the evidence against him in this case, they'll realize that the persistence of bar counsel in prosecuting this case was absolutely called for. The allegations against him were significant and required obtaining various witnesses to testify and documentary evidence, and bar counsel did her job in establishing that Mr. Septowski violated 5 or 6 disciplinary rules in this case. And Mr. Septowski points out that bar counsel went to a hearing. Well, that's not surprising at all, in that that hearing went to the very heart of the issues in this case. That hearing was before the bankruptcy judge, who was considering whether Mr. Septowski had improperly used another attorney's name, whether he had been practicing while suspended, whether he'd been practicing through his paralegals. And so to call that targeting is very misleading. Bar counsel was simply doing her job in this case. I think that has addressed all of Mr. Septowski's substantive arguments, but I would remind this board again that there is ample evidence in the record below to support this judgment of disbarment. Mr. Septowski has pointed to no issue that would require reversal by this board, and the commission respectfully urges this board to affirm the judgment in all respects.
Ms. Stevens, yes, I'll just complete the record. Is it 2.18 imposition of sanctions where it lists A through J that you were making reference to earlier?
That's correct, yes, sir.
Any other questions? Thank you very much. Septowski, you have 5 minutes.
Thank you, sir. Ladies and gentlemen, thank you for letting me respond. I'm taken aback a little bit listening to bar counsel, because those are hurtful statements. I never had any intent to violate any rule. I screwed up. We created a typo. I got a posting wrong. I have a withholding of an escrow that was not withheld. And then I have substitute counsel that's screwed up, and it has all sorts of related activities. Once it's screwed up, it's screwed up. Of course I'm responsible for all the rest of it, okay? None of it, individually or collectively, constitutes reasons for disbarment, constitutes reasons for slapping me on the wrist, constitutes reasons for taking 40 grand, constitutes reasons for lots of stuff, but doesn't constitute saying that I'm a harm to the profession or my clients. The first canon in the DR says you take care of your clients. I did that. And when forced by compulsion, by opposing counsel going forward in the state court case. And by the way, the state court action was that I didn't respond to emails.
Mr. Septowski, you can't take care of your clients during a suspension because you may not have clients during a suspension. Did you advise your clients that you could no longer represent them?
Yes.
So you had no duty to them. They had the duty to find counsel if they needed counsel, but you weren't doing something to help your clients because you had no clients at that time. Wouldn't that be correct? Did you have clients during your suspension?
Of course I couldn't have clients during the suspension.
Did your office have clients during your suspension?
No.
All right.
I also don't leave people
But your
hanging.
argument was that you were helping clients, and
Yes, I was helping people that were left in Never Never Land. The husband had a heart attack.
Isn't it their responsibility?
Pardon me?
I think what Mr. McKetta is saying, and
Is it my responsibility?
Oh,
Mr. McKetta says no. The canons say yes. And I tried, it says never leave a client in the lurch, okay? I tried to do the best I could, which was get somebody else. okay?
The legal point
I
is
did
they
it
were no
wrong.
longer your clients. Therefore,
Yes,
the canon
legal
did
points
not
are no
apply.
longer my clients, but there are people that are counting on me, and there are people that looking to me to help them and save them. And
If they
I
were still looking
managed
to
do
you,
that.
you were not making clear to them, were you?
No, sir. I
That you had
did
no
make it clear
power.
to them.
You had no
And
power.
I did make it clear that we had to bring in a substitute counsel, and I did make it clear that we had to, that their interests had to be preserved.
Did any of them talk with substitute counsel?
No. They didn't. They said, take care of it for us. So I had my assistant take care of it. Turned out he didn't. That's wrong. I should get spanked for that. Okay? I screwed that up. But I was as surprised as anybody when we were in that bankruptcy hearing. And that's on the record. I didn't know. Okay? I'm responsible, but I didn't know. All of this suggests, all the representations here, are that I intentionally violated a bunch of administrative orders that if picayune would be a nice way to describe them. Okay?
Here's
But
my
the
problem.
bottom line
Today,
here is
I'm not
I didn't
hearing
do
you take
anything wrong.
accountability. Today, I'm not hearing you admit that you were suspended for 3 months.
Yes, sir. I
And that
was-
you were still taking care of clients.
No, sir, I was passing it on to people to see to it that the clients were taken care of. I couldn't leave them in a lurch. Maybe that's what the
So
board
help me
rules
get an
require.
example of what it is you told to client X
Yeah.
about the Alaskan lawyer. What did you say to that client?
I told them, look, we've got a person that was my former assistant. We've looked to them to act as assistant counsel in this matter, and I'm told that they have. Okay.
Did you give the phone number to the client, to the former client?
No, I didn't.
But you were
try to
still
hide or exclude
handling the
anything.
legal affairs of the client during a period of suspension.
No, sir. I was handing it off and saying, look, this is the best I can do for you. Okay? Did I do that right, or did I do that as well as I could have? Probably not. But I've been taking care of people for 35 years, with or without a bar license, with or without a CPA license, with or without any license, because that's the kind of person I am. You do what's right. Now, I didn't intend to
Sir.
violate any of these rules. If I did,
Sir,
I did.
let me
I
stop
get
you right
spanked.
there. Do you understand that as a lawyer, you are solely responsible for supervising the people in your office to make sure they don't do anything that violates rules and breaks
Yes,
the
ma'am.
law or any of that?
Yes, ma'am.
So
And I'm responsible for that.
can
No
we
issue.
agree that I didn't know, doesn't matter under these rules? You are responsible for supervision of
It
your
does
system.
matter as to whether or not I intentionally did it. Am I responsible for the outcome? Yes. Am I responsible for knowingly and willingly violating the suspension? No. Because I didn't intend to. There's other lawyers that I could have brought in and emails that said, look, I can't talk to you right now. Can't do anything.
What action did you
Okay.
take against the assistant that supposedly, without your knowledge, used a false name and a false bar number and all that? What action did you take against
I've had
that?
him for 20 years. He's got cancer, and no, I didn't do anything to
You
him.
just said, oh, well, I didn't know.
No, I said, you put me in a bad place, okay? And that's the way it is. He understood he made a mistake.
No, sir, he didn't make a mistake. He blatantly lied
He
to
didn't
a
do what
court.
he was requested to do.
He blatantly lied to a court. Can we agree on that?
I'm sorry, ma'am.
He blatantly lied to a court.
No, ma'am, he didn't lie to the court. He told the truth. He said, look, I didn't do it.
He filed a pleading from your,
No, ma'am.
okay, I'm not gonna argue with you.
He didn't file any
Mr.
pleadings.
Stepp, hold on.
He didn't know how.
Hold on. Mr. Septowski, your time is up.
Let me,
hold
may I
on.
make one conclusion?
No, hold on. Your time is up. Does anybody else have any questions?
No.
Thank you very much. We appreciate the argument. We will take it under advisement and advise you of our decision. Thank you. We are adjourned.